We are on page 14. Just let me say, all of their lying, all of their covering up, all of their collusion, all of their cheating, all of their avarice doesn't change the facts. The facts are there, they will be there forever. They can lie about it, and West Publishing can print the lies, but the facts do not change. And guess what? Guess what? Guess what, Mr. McCabe, Mr. Rudolph, and Mr. Lippman? Guess what? And the law doesn't change. They are there. The facts are on Glendora's side, and the law is on Glendora's side, and you're not going to change that. And we see through you, you're gossamer. Well, where were we? We are on page 14. I've got to read you 14 and 20, and then I have to haste to the mailbox and serve these papers. They have to go out in today's mail. So we're up to theta. And this ghostwriter for these three punks, defendant Masterilli says, she stated a meritorious excuse that her employer was to undertake the defense. I never heard her state that. I never saw anybody bring her to the witness stand. I never saw her under penalty of perjury, so help her God, state that. You just don't think we notice these things, do you? You are pathetic. Glendora says, A, what was the meritorious defense? B, quote, that her employer was unable, that her employer was to undertake, by the way, this is their 26th lie in this paper, that their employer was to undertake, and next comes funeral, as in Callaghan, undertake the defense. Well, it did not happen. And how does that absolve Cecilia? And specify what is meritorious about that, and convince that is any defense at all. And municipal judges are smarter than Supreme Court judges. Iota, and this ghostwriter for these three punks writes, particularly as the employer and not Masterilli was mentioned by name in the statement of the nature of the action. Oh, that is so sick. That is so subhuman. Glendora says A, and this is their lie number 22. This is not so. It's just plain not so. And you prove it to me. And even if it were so, it is not a valid defense. As their defense counsel, you are slipping. These three judges are paying these law clerks, or one law clerk, to be the defense counsel for the defendant. Isn't that great? Isn't that adjudication? Isn't that fairness? Glendora says, we feel sorry for you desperate people, so we will sue you again, and you along with them. And what is your name? Ghostwriter, what is your name? I've seen ghostwriters sit in court in the jury box, taking notes and figuring how to get around justice, how to circumvent justice. Kappa. And ghostwriter says C. Steve Macchionda and Associates versus Max. Oh, who cares? How is that relevant? It's stated out of context. It doesn't say how it applies, and even if it did apply, it's not law. We need law. We don't need your cases. Cases are not law. Law is made by the legislature of the state of New York and the Congress of the United States. How is this relevant? It is out of context. We need law, not meaningless computer spit-outs and washouts. Lambda says this ghostwriter for these three punks, Rudolph, McCabe, and Lippman, counsel promptly sought to vacate the default after it was ordered. Out and out lie! Where are your facts? Where are your dates? And Glendora says, how much did you get paid as his defense counsel? Promptly, you say? Is your lie number 31? 95 days is promptly? Kid us not. It is promptly by your standards. You take so long to do your work. And then you never do it, which is to enforce the law. Page 15, move. A meritorious defense has been demonstrated, says this ghostlight writer, for these three liar, for hire, appellate judges, whose names are what? Yes, McCabe, Rudolph, and Lippman. And this is your big lie. A meritorious defense has been demonstrated. You just out and out lie. But it doesn't change the fact, and it doesn't change the law. Number lie 32. We feel sorry for you. You are in a pitiful something state of human development. Aborted. That's what they are. They have never seen their full development. Their development has been left in a rudimentary state. They are aborted. Your growth has been checked by your sickness of doing evil. We are up to up to point new, as this ghostwriter writes. As plaintiff did not make any showing in the complaint. The complaint was not the issue. This was small claims court. You're not even supposed to have a complaint. You're supposed to have a small claims application. Default judgment was the issue. The complaint was not the issue. Default judgment was the issue. So they're always trying to bark you up the wrong tree. They're always trying to deceive you. They have deceiving hearts and deceiving minds. But what can you expect of judges and clerks who cannot read and turn cases upside down? Angelillo turned my case upside down. Angelillo made it was Glendora versus Cablevision in the Harrison court down through Langelotti, and he turned it upside down. Glendora versus Langelotti. What can you expect of people like that, who are upside down, who stand on their heads, and who cheat and lie? Masterulli had to show a meritorious defense for default. Glendora could have written a better defense. The problem is that Masterulli had no defense. Sorok had no defense, and you have no defense, and you are a cauldron of cunning colluders who write conclusories and not law, and not fact, and not grounds. Everything they say is conclusory. There is no law. It is all dictum. And it's all manufactured, and it's all rationalization, because they got to make it come out their crooked way. And they are so pitiful and so pathetic. And Ghostwriter writes this: that would be sufficient to hold Masterulli personally liable in this matter. Out and out lie. God save these people. These poor, pathetic, dumb people. Glendora says, well, you prove this. You think by sneaking this in with a bunch of other phrases that you will get by with it. Well, you will not. You have been caught, and you have shown how abysmally you have made New York State's corrupt. It's a fact. It's out there now. And it's in front of all these TV stations, and it's in front of 2 internet sites worldwide. Omicron and your lies number 38, 37, 38, 39, and 40. Ghostwriter writes. See this? You have to take this apart phrase by phrase. Every phrase, practically every word, is a lie, which sounds in tortious interference with contract. Well, it does not. It sounds in damages small claims. You don't even know small claims. You don't even know there has to be a trial in small claims. And so Glendora says this is small claims action for damages. It has nothing to do with any of the stuff that you quote and spit out. It is not contract. Lie, lie, lie. How can you do that? How can you sleep at night? I'm talking to you ghostwriters, and to you, Lippman, and Rudolph, and McCabe. How can you do that? To the United States of America, and to the state of New York, and to the people. But Glendora says, what can you expect of 3 illiterates who cannot read, and furthermore, who cannot write? According to English construction. The interference was New York Public Service Law, Article 11, Section 229C, but that is not the cause of action. Was it or will it sink in this time if Glendora tells you it was a small claims action for damages, the money these defendants caused Glendora to spend? It is called substantial justice. Did you know that? Yes, small claims has to do with one thing only, not all this stuff that you're spitting out. It has to do with substantial justice, which is a big word for money. Have you ever heard of substantial justice? Who? You, Lippman, McCabe, Rudolph, and your 2 ghostwriters. And then they spit out another one of these meaningless, irrelevant, useless cases, thinking you're going to think it's law. Well, we know darn well it is not law. We know it for what it is. It's another stupid decision by a stupid judge. And what does this prove? It proves that you should lose your job, and that you should lose your pension, and that you should go to jail. To these ends, we are committed. We got rid of de Blasio, and he was nearly as bad as you. Things are pretty bad when Glendora has to correct every phrase that you write. Even Sorrow lets her correct a paragraph or 2 at a time. But you, I have to correct every phrase. We're on page 18. Ghostwriter writes, nor for that matter, has plaintiff made any showing that there was any contract, quote unquote, between herself and the local sponsors to be interfered with in the first place. No, I didn't, because that wasn't the issue. There was no contract. The issue is not contract. Where are you? I don't know where you are. You're way off the road somewhere in the field. There was no contract, and I made no issue of it because that's not the gravamen. The gravamen was damages. You have been caught. You have been caught badly. Glendora did not make this claim. You did. What can you expect from 3 judges and 2 lawless lawyers, law clerks, who do not know how to read? You turn the case caption upside down in Glendora versus Charles F. Dolan through Angelotti. You can't read the caption in this case. You left out a defendant, Jill DeCrenza. You don't know how to read. You don't know the law. You don't know honor or ethics or morality. You see, Glendora's 50-page excoriation of you on TV and on 2 internet world wide webs. And so, this is how law clerk leaves it. A nothing, as you can see, all blanks. And Glendora says, that was another 50 lies by you. And what can we expect from you is total, unresisted, hear me well folks, self-surrender to vice. Open and shameless disregard of decency. Utter laxity of morals, abandoning all restraint, and complete insensibility to reproof. That's all we can expect of you, Kenneth Rudolph, Edward McCabe, and Jonathan Lippman. Oh, it is so sad. And Christ is right. You know, you have to turn your back on this world. And you can't spend your time thinking about this. You have to spend your time thinking of that blue sky out there, and that sunshine, and all these magnificent galaxies, millions of light years away, and how tiny we are compared to the vastness of the universe. And you have to think of the variety, and that you have the galaxies, and then you have the planets around a star, and then you have a planet that has warmth and water and soil. And out of this makes life, makes planets, makes plants, and makes people. And then you have to think of the good people who are trying to save the world from these crooks. Christ was right. That's where you'll find fulfillment and completeness and achievement and accomplishment. So why do I do this? I'm trying to draw them to their happiness, their fulfillment, by showing them that their lies aren't working, that we all know what's going on. And I really honestly think that if I show this on TV enough and on the internets enough, and if I put it in their faces enough, that one day they will acknowledge, repent, reform, restitute, and one day they can rejoice. So, praise the Lord, that was some page to refute. Let's go on to their small claims, SM-4, whatever it means, upsilon. And it says, finally, this is the crooked, rationalizing, lying, sold soul, lawless clerk, winding up. The decision on motion, quote unquote, from which the appeal was taken, is an appealable paper in all respects, save its title. They will twist, they will lie, they will spin, they will do anything to cheat. And Glendora says, of course you would say so. And how else would we expect your prejudice to swing you? It's anybody surprised? Well, I'll tell you that Mr. Siegel, in Siegel's practice, picked up on that and said, Appellate Term, you're nuts. And you're cheating. And right down here, can you see what it says? General practice. Court holds decision on a motion appealable because it was equal of order to all respects save the title. You can't even understand it. It's not even intelligible English. They don't know. The appellate term, you don't know Rudolph and McCabe and Lippmann, do you? You haven't learned yet. that only an order or a judgment can be appealed. Nothing else is appealable. Only an order or a judgment. This was the title of this paper that Sarok appealed, was decision on a motion. You cannot appeal a decision on a motion. But what does this cheater law clerk do? Covers up and goes just the opposite and says just what isn't the law. They will do anything. They will stoop to any level to lie their way and rationalize their way. And so here is where Siegel's practice says, in Glendora versus Masterilli, appeal was from a decision on a motion. Glendora said it was wrong. Glendora told the appeals court it was wrong. Glendora made a motion that the whole appeal should be quashed and the $5,000 returned to its rightful owner. But they got a lie. Yeah, they'll do anything to get the $5,000, won't they? And whom am I talking about? Littman, Rudolph, and McKay. That no appealable paper in all respects save entitlement. Cheat, 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 cover up, cover up, cover up. Lost life, lost life. And Siegel's practice says, you're wrong. Appellate term. Now just let me go back. They can cheat and cover up all they want. But the facts don't change. And the law doesn't change. Now it is time that you three judges listed the papers that you read. I don't think they read anything. And you should do so under penalty of perjury. I want every one of these judges to say under penalty of perjury that they read the papers and that they understood them. And further, Glendora should give you a test on what you read. But oh, we forgot this. You can't read. You don't know how to read. You can't read captions. And so, we're up to page 20 and we're going to run and serve these papers. Glendora says, nowhere are you able to stand up to Glendora's arguments against irresponsible, anti-society, acquisitive Sarok. The dumbest court there is knows enough to give something to both sides, but your prejudice is unilateral. Now comes the part, and this is what makes the paper a nullity along with 15 other things. This is no signature. No signature. Do you see a signature there anywhere? What is one to get out of this frivolous verbiage? Everything you've done is not only a cheat, but it's frivolous. Everything you have done is not only a lie, but it's illegal. Do you charge by the word or by the sentence or by the paragraph or by the page? How much do you get paid per unit? When I sue you, I get discovery, and I will ask, and that includes you, ghostwriter. Which ghostwriter wrote this swap? The paper is not signed. The paper is not signed by 3 judges. The paper is a nullity. It is null and void. The prolixity about press, paper, not being an appealable order, is juxtaposed by these 3 not having a genuine ruling. Glendora is jubilant. Frivolous 5 pages adds up to 0. Master really owes Glendora $5,020 plus costs and disbursements. This is solemnly ratified, so be it. Amen. I'll be back. In a few minutes. McCabe, Rudolph, and Lippman, and ghostwriters, and Sarok, and sadly Stevens, Burke, and Burr, and Cecilia Masterilli, and Cablevision, and Charles Thillen, and James Dolan. You simply did not get away with it. I'll see you shortly. A copy has gone to Rudolph, a copy has gone to McCabe, a copy has gone to Lippman, the 3 bad actors, plus a copy to Tannenbaum, plus a copy to Angelillo. This to show these 5 abusers of the court system that they're not getting away with it, that we know about it. And then the paper itself has to be served by a third party, and that will be done in White Plains. So, where are we? We've made the point that the paper wasn't signed, that the paper is therefore a nullity, that the paper has not been pronounced judicially, that the paper has not been decided judicially, and it is null and void, and the prolixity about press paper not being an appealable order is juxtaposed by these 3 not having a genuine ruling, and we've shown you that Siegels said they're wrong. And Glendora is jubilant, and frivolous 5 pages adds up to 0, and Master really owes Glendora $5,020 plus costs and disbursements, solemnly ratified, so be it, Glendora, and that's page 21, twice. And Matthew 22, you shall love the Lord your God with all your heart, and you shall love your neighbor as yourself. I do. And that is why I am working so hard to redeem these 7 souls and their ancillaries and their adjuncts. Adjuncts cannot adjudicate. This appeal has not been determined nor pronounced judicially. These 5 papers are meaningless, frivolous, and puerile. They are neither American nor Empire State. They are mere pawns of ulterior bosses. As I told you, the courts are a mob. I don't know which mob it is, but they are a mob. You don't do what the mob tells you, you're out. So that's why there's no good people in the courts. They're out. So what do you pray for them? Why, you pray that they be free from imperfection, that they be free from limit or restrictions, that they be determined by themselves and not by anything outside of themselves, that they be not dependent and not relative, that they be ultimate what they are, and that they be intrinsic, real human beings.